I'm really honored to be here today and to share with you some history and some law because we have a lot of unresolved issues here in central New York. And as we all know, this is the homeland of the Onondaga Nation. They are still here, still thriving, still exercising their responsibility to be stewards of the natural world. And we are very fortunate to live in the homeland of the Onondaga Nation because of the wisdom that they bring to us under the Haudenosaunee Great Law of Peace. So I'm just incredibly fortunate to have been able to work with them for as long as they've put up with me, to have spent so much time with several of their elders who patiently helped me understand some of the things that I hope to share with you this afternoon. So what I want to share with you is that we have some very deep current conflicts within U.S. Indian law regarding indigenous land rights and how we might work together to bring healing for the centuries of harm to the Onondaga Nation. Stated another way, how did we go from Onondaga having stewardship of 2.5 million acres to now, until very recently, only 7,500. We added 1,000 to that a year ago. We'll come back to that. How does that confinement come about, and how do our courts not resolve the problems that come from that? And what do we need to do now together as a community to keep working towards a healing of these centuries of problems? What should the governments do to address the damages from all this history? And to understand this, we have to review and understand history. I graduated from Maxwell in 1968 with a history degree. And that's been very valuable as I have worked with Haudenosaunee leaders who are almost constantly talking about history. So the short answer to how we got here is that the homelands were lost because New York State took them illegally, knowingly took them illegally. The federal courts have ruled in two different cases, both Oneida and Cayuga, after extensive historical hearings, that New York knowingly violated federal law when it engaged in a series of takings against the Oneidas, Onondagas, and Cayugas. They all happened in a very short time frame. But despite those rulings, the federal courts then turned around and said, there's no remedy here. You've waited too long. We'll go into that a little bit of how that happened. So most of us know that this is a painting by Faithkeeper Warren Lyons. This is how I'm instructed to begin every talk by the Onondaga leaders, which is we must think back to what was going on here prior to colonization for a couple of really critical reasons. One, all of the land and water was clean and pure. We read colonists coming up in the 1740s to crow about the fish, the abundance of fish in Onondaga Lake. So all of the water was drinkable. There were edible fish everywhere. We'll see how much their territory covered. And we also have to think about their loss of jurisdiction over the last 250 years, the attacks on them over the 4 centuries, and putting all that together, what the US courts have done in the last 30 or 40 years. So we know New York took, so at the end of the Revolutionary War, the colonial settlements essentially ended in Schenectady. There was very little white settlement to the west of that. In fact, when you see maps from 1776, they clearly show country of the Six Nations. And after the Revolutionary War, New York was broke. It needed to compensate the soldiers, and it needed to expand. At that time, Massachusetts claimed Western New York because Massachusetts had a royal charter that went from the Atlantic all the way to the Pacific. That issue was not resolved until 1876 when an agreement was made between the two states, and Massachusetts waived its claim. But that's an indication that there was no colonial or state jurisdiction at the end of the Revolutionary War. Next slide, please. And in order to really understand the Onondaga's point of view, we have to understand how central land is to indigenous cultures. And the nation sent me to Standing Rock for 2 weeks back 9 years ago now. And there I was reminded that to the Lakota people, the Missouri River is a living relative. And in the same way, Onondaga Lake is a living relative to the Onondaga Nation and its people. They have obligations to carry on ceremonies and relate to their relative. And when their land and water is taken away from them, it has a very, very far-reaching negative consequence. We know that they begin all of their meetings with the words that come before all else, where they thank the Creator for all of the aspects of the natural world that are still doing their job so that we can continue to exist here. Their clans are named after natural wolf, bear, deer. I've handled a lot of cases involving their treaty protected rights for hunting and fishing and gathering. I think we finally convinced New York State that they can't ticket indigenous fishers, except under very, very limited circumstances. That only took 30 years. And they always tell us to make decisions for the 7th generation, which would be a very refreshing way for many of the decisions that are being made now. Next slide, please. So this is their original territory, and it runs from the Thousand Islands in the north. I grew up in northern Oswego County there. We have a French drawing from 1684 that shows the French meeting with the Onondaga chiefs where the Salmon River meets the lake. And so prior to colonization, they fished and hunted and gathered throughout this territory. Thousands of places to fish. And today, you probably can't even see their currently recognized territory. So how did this happen? Next slide, please. This shows us the same thing. This is a 1904 or 5 map by the New York State Museum. It shows the various nations' original territory. This is actually very early on, because in the 1600s, many of these nations were either driven further west or were brought into the Confederacy. Next slide, please. And this is what happened immediately after the Revolutionary War. The wilderness, and that's what it was. About 3 weeks ago, we were fortunate to hear a lecture by 2 authors about the 1779 Sullivan-Clinton campaign, how we could be fortunate to hear about such a horrible event. I probably should have a better word, but they explained that, and for those who don't know that, here at Onondaga in 1779, New York and Washington sent an army to destroy the Onondaga village. There was a historic marker near the city greenhouse between Upper and Lower Onondaga Park. I used to walk my dog past it. that said Indian attack. Well, what they meant was that after the colonial army had destroyed the village, killed many women, children, and elders, committed many rapes, destroyed the vegetable garden, and cut down the orchard, and were retreating. The men came back from having hunted and tried to attack the colonial army. And that was preserved as Indian attack. And that's part of the problem of really getting to the history of what happened here. So Washington sent an army, two armies actually. The first one was in April of 1779 and destroyed the Onondaga village. And then in September, the armies came up from the south along Cayuga and Seneca Lake and destroyed hundreds of villages of those nations, cut down thousands of fruit trees, and tried to reign of terror. And the result of that is that most of the leaders, particularly of Onondaga, moved to British protection over near Buffalo, in Buffalo Creek. And New York knew this. And the soldiers in those raids said, these are unbelievably beautiful lands. These people are living in houses better than ours. And so the thirst for those lands actually began during those raids. But what's helpful in this, these are military tracts. So you take a wilderness and you can modify it. That's what this does. Many of these boundaries are still reflected in town boundaries today. And one thing we can learn from this is it says Onondaga Reservation there. That reservation still exists under federal law today. And I'll come back to that because of a decision that Justice Gorsuch handed down 5 years ago. That is the current Onondaga Reservation. What does that mean? Well, we'll come back to that and maybe we'll get closer to having some answers. So New York made agreements with people they knew were not leaders. They had driven all of the leaders away and they found anybody they could back here and said, we'll make a deal with you. And they made a series of those agreements. Unfortunately, from New York's point of view, all of those were in violation of federal law. The Constitution is very clear that only the federal government can handle Indian matters. Article 6, Clause 2 says treaties are the supreme law of the land. But New York needed the land. And so they kept at it. We have records of multiple written communications from the Washington administration to New York. It was causing Washington a problem. In 1790, 1791, colonial armies were losing a war in Ohio. And Washington could not afford to have the Seneca warriors join their friends to the west. That's why he commissioned Timothy Pickering to commence the Canandaigua Treaty in 1794. He used Haudenosaunee protocol to bring the Haudenosaunee there. He sent out wampum belts, wampum strings to invite people. Over 2,000 Haudenosaunee came to Canandaigua and for over 2 months negotiated and eventually signed a treaty that defined that reservation. There's some historical, legal problems that's all that's recognized as a reservation, but that much is recognized. New York, it didn't bother New York. They proceeded to make 4 more takings. None of those takings involved either the federal government in the negotiation or the future ratification. We have a law in New York that's called it, in the US, called it the Trade and Intercourse Act. And That's a law that Washington asked Congress to specifically pass to control New York because they were causing him problems. It's a very simple law. It's 25 U.S.C. Section 177. It says that any taking of Indian land that does not have a federal negotiator involved originally and that does not get federal ratification afterwards is void. Void. Pretty clear. That's the law that the land claims and the Onondaga Land Rights Action was built on. The problem with the law is it gives no remedy. And we'll see what the courts did. So federal law says all of those takings are void, and yet it does no good for the Onondaga Nation in their jurisdiction. So military tracts, commodification. How does this happen, and what does the U.S. law say about it? Next slide, please. So there is a concept, a construct in U.S. Indian law called the doctrine of discovery. More recent writers describe it as the doctrine of Christian discovery and domination, but it is still central to U.S. Indian law, and we will see how that happens. So what it says is that, and it starts in the 1400s, first with the papal bulls in 1450, Portugal had begun to colonize and plunder northern and western Africa. And the Catholic kings in Portugal and Spain asked the Pope for his blessing, his support in that colonization. And so in 1453, we'll come back to that, that's the next slide. What the concept is that when a European nation, which are all Christian, lands on newly discovered lands that does not have Christians, and this is how it's written, then the title to that land automatically reverts to the Europeans. And the indigenous people are left with a right of occupancy. And then to make it worse, the United States claims the right to terminate that right of occupancy at will. That's called plenary power. It's totally unconstitutional, but it's the structure of U.S. Indian law. And in fact, Gorsuch cites plenary power in making a good decision without even using the term. Next slide, please. So here we are back to 1453, I think it is. And the Pope authorized European nations to invade, search out, capture, vanquish, and subdue all Saracens and pagans, and to reduce their persons to perpetual slavery. Next slide. Just to emphasize that, and to take their possessions and property, all of it. So the Pope is telling Portugal, and then subsequently Spain and other colonial empires, we'll get to that, that you can go anywhere in Europe, anywhere away from Europe, and by planting your flag there, that becomes yours. You have the right to enslave all the people there and to do what you will with them, essentially, and to take all of their land and possessions. What could go wrong? Next slide, please. And so, you hear that, you think, oh, that's old. Why is he talking about the 1400s? And there were a series of papal bulls after that first one that I just showed you, because the year after Columbus, I could say found his way to the Caribbean, but that might be overly generous. But in 17 1493, the Pope issued another papal bull essentially saying the same thing. Then there's a series of papal bulls going into the early 1500s where he is helping divide up the property, the lands in the New World between Spain and Portugal, the line of demarcation. All of this is about colonialism, and one of the reasons for this is so that the colonial powers wouldn't fight with each other, that Portugal would honor the claim that Spain made over here. But the real impact on it was the decimation and annihilation of all of the indigenous people in the Caribbean, and then the subsequent removal and alienation of all of the indigenous people here in North America. And somehow it gets into US law. 1823, a case is essentially colluded between the parties fighting over title to property in either Indiana or Illinois. And a law professor, historian with whom we've worked, found documentation that showed that those two parties worked together, paid each other's lawyers, and said, we have to get a case up to the Supreme Court, particularly to John Marshall, so that our right to take the title to these lands is recognized so that we can make profit. And you have to understand that land speculation, I don't know if I got that slide in here. Land speculation was one of the major sources of wealth, particularly for the landed families in Virginia and along the East Coast. There's a new book called Speculation Nation, which I highly recommend. All of the founding fathers were land speculators. Washington, Jefferson, John Marshall and his family were notorious land speculators. And the concept there was that we'll buy the right to title to indigenous lands on the west of the Appalachians, even though they have indigenous nations still living there, not even knowing what's going on over to the east. And once we get that title by claiming it, we can then flip it, sell it. And that's what went on a great deal. New York sold the land they took for 5 to 10 times what they paid for it. And so land speculation was the second major source of wealth in the new republic, second only to slavery. So they needed to bring this, they needed to get some legal cover for this. And that's what the case of Johnson versus McIntosh provided them. And it was a relatively simple title dispute. It could have been answered in 5 pages. Marshall went on for over 30. And this is when the doctrine of discovery is brought into US law. And he says that the Indians were rightful occupants. There you have that title again. But their rights to complete sovereignty were necessarily diminished because of an original fundamental principle that discovery gave exclusive title to those who made it. Well, I'm not sure how original it was. And we'll see how he plays that out. And he clearly says that the different nations of Europe asserted ultimate dominion to be in themselves and claimed and exercised ultimate dominion over the power. That means complete control. Next slide, please. And he knows that people are going to challenge that it's so extreme that he has to justify it. And so he writes, however extravagant the pretension of converting the discovery of an inhabited country into conquest may appear, if the principle is asserted in the first instance, in other words, you just claim it, and then you keep repeating it, and then you put a bunch of settlers on the land, that's the end of the discussion. If we apply, and you might see some of this coming out of Washington today, we see all of this nonsense with an original statement that has no basis in fact or reality or morality, and they just keep saying it. I'll try not to go down that. Next slide, please. So 202 years ago, the doctrine comes into US law. And this is interesting too, and it has a modern corollary. And so Marshall does not cite the papal bull. Instead, he bases this claim on the 1496 royal charter to John Cabot from the English king, because by then, the Church of England had split off from Rome. And so the king had to create a new cover that wasn't based on Roman authority. Exactly the same one. And we all know that that split still exists today, because we had a historic meeting between prayer session between the Pope and the King of England, who is the official head of the party. So the king uses the same terms when he grants a charter to Cabot. His name was not John Cabot, it was Giovanni Cabato, but we had to make him sound English. And he grants him the power to sail to all parts and regions and coasts, and to fight, to find and discover whatever lands, and also the power to conquer, occupy, possess whatever such towns and cities that he discovered, conquer, occupy, and possess. The same, you can go there, take absolute control over the indigenous people, and do as you will. So that's what Marshall referred to in Johnson versus McIntosh. Next slide. And unfortunately, it's not just 200 years old. March 29th, 2005, and I remember that date so well because it was 18 days after we filed the Onondaga Land Rights Act. That's 20 to 30 years of discussions in the Longhouse, some very careful planning, some waiting for the Cayugas during their trial. And finally, March 11th, we filed the Land Rights Action. It was a very big day for the nation. 18 days later, Cheryl is handed down by the Supreme Court. I read it in my sister-in-law's house out in Arizona off the facts and said, oh boy, there goes the case. You could read there that that was the end of land rights for the Haudenosaunee. And Cheryl involved the Oneida Nation. So prior to that, and we have at that point, the Oneida land claim was 40 years of history of litigation still active. The Cayugas is over 30. And there had been rulings primarily by former Judge McKern that he was not going to award either nation the clear return of any of these stolen lands. He just said, that's not something I'm going to do. And so all of the nations learned that no matter what success might come out of the land rights and the land claims, it wasn't having title to land directly returned. And so the Oneidas and Onondaga has done the same thing, bought up property from willing sellers within their Canandaigua reservations, saying, well, if we buy back stolen land, it should be ours. We should have full jurisdiction. And so they refused to pay taxes and accept zoning and other local jurisdiction. The city, for some reason, these cities over towards Rome are the size of counties. So the city sued them and it went up to the Supreme Court. We filed that case very carefully, obviously, because it has to do with, it's going to have an impact on Onondaga. And the result, we'll get to that, what the result was. So this is an 8-1 decision by former Justice Ruth Bader Ginsburg. I call this the Plessy versus Ferguson of Indian law, because it's that bad, it's that wrong, and it's that racist. And it has to be overturned. Her first footnote goes back to the doctrine of discovery. These are her words. Under the doctrine of discovery, the land occupied by Indians became vested in the sovereign. first the discovering European nations and the state, then the United States. That sentence alone is pretty, I submit, radical. But then, next slide, please. The second sentence in the footnote is even more troublesome, because she admits that both before and after the adoption of the Constitution, New York acquired vast tracts of land from Indian tribes through treaties. She should know better than that. States do not have a right to make treaties, but she uses the term incorrectly. It independently negotiated without federal participation. So what she has admitted here is the factual basis of a clear violation of the Trade and Intercourse Act, because after the Constitution, it is clear that only the federal government can take Indian land. She says New York took it before that without authority, but it doesn't matter. It just doesn't matter, because she makes the ruling that it wouldn't be fair for Indians to raise these problems anymore. She makes up a defense that she originally calls laches. Laches is an equitable theory. We have law on one hand and equity on the other hand. Equity came out of the church courts in England in the Middle Ages because the royal courts were not really fair. And so there are a very established set of principles of equity, all of them ignored in the series of rulings that we're going to continue into here. So she says it's not fair for the nations to raise these old problems because we conclude that it would upset the justifiable expectations of the settlers. No proof whatsoever about disruption or what the justified expectations of the settlers are. I read every word of the briefs. We listened to the oral argument. This comes out of thin air. But this is how she starts, by justifying that on the doctrine of discovery. Let me just see where we are here. And so what she says is it's not fair for the Oneidas you can't rekindle the ancient fires of sovereignty, is what she said. You can't wait that long. Well, that's another erroneous ruling because, and so when we saw this, we immediately amended our complaint in Onondaga. We submitted over 1,000 pages of historians' affidavits and writings to show the courts were closed to Indian nations until a ruling in 1985 in the Oneida land claim. In fact, prior to that, the federal courts had ruled you can't bring this claim. So claiming that the Indian nations waited too long is again ignoring reality. And yet all of this is in an equity. And so you see, she said, you can't wait that long because it's not fair to the people that now live on the land. There are principles of equity that mandate that a defendant cannot use the protection of equity if she is the original wrongdoer. Here, New York is the original wrongdoer, and yet they're underhanded a vast defense that does away with the land claims. So that's Cheryl. Doesn't get any better. Next slide, please. So immediately, the Second Circuit starts dismissing Haudenosaunee land rights in June of the same year. They dismissed the Cayuga land claim. Now, at that point, Cayuga only had the only verdict that they came out of the federal court here with was a $250 million money judgment. No land, nothing else, money. Not really disruptive. Didn't bother the Second Circuit whatsoever because they then said that Cheryl has dramatically altered the legal landscape of all Indian claims. And we understand that these equitable defenses, just so fair, you know, it's hard to absorb. Even when they're filed within the statute of limitations, we can find that they're not timely. because one of the few incontestable propositions about this unusually complex and confusing area of law, Indian law, is that doctrines and categories applicable to other areas do not translate easily into these claims. In other words, we have a totally separate set of rules for Indian land claims. Next slide, please. 4 years later, the same Second Circuit dismisses the Oneida land claim. And again, by this point, it had been up and down throughout the federal courts for 40 years. First, no, you can't bring it. Then you can bring it. Now let's figure out what the remedies should be. And, oh, no, you lose. That's the history of the Oneida land claim. And here, because there's a lot being written about this, this is before my third law review, but a lot of people were writing about how incorrect and unfair Sherrill and the dismissal of Cayuga was. And they see this, they understand this, and they say, well, okay, so we use the term latches here. It's just a convenient shorthand for equitable principles again. Somewhat imprecise. In other words, we're just kind of fudging it as we go along. And they admit that the Oneidas correctly pointed out that the defendants had not properly raised the support for their defense. Doesn't matter, because we're not using traditional latches. We're using something else in order to deny Indian justice. Next slide, please. And then finally, we have the Onondaga case. We had a very short lifespan in the Northern District. We got to argue one day. And then Judge Kahn over in Albany he felt mandated to dismiss the case under the Second Circuit and the Sherrill decisions. So we went to the Second Circuit. I got to argue that appeal on Columbus Day, 2012. Columbus Day, okay? It's lucky that the Onondagas have somehow maintained a great sense of humor, because you kind of have to. And they gave us 10 minutes. Normally for an appeal of this nature, you'd have 20, 25. It was a given what was going to happen. And 1 week later, they dismissed our case, affirmed the dismissal of our case would be accurate. And it says it's just the same as Sherrill and Oneida and Cayuga. And, you know, here's the factors we can list. The length of time between the harm. Because all of these takings are more than 200 years old, there's one strike against us before we get into court. The disruptive nature of the claims long delayed. We submitted substantial proof that the Onondaga land claim has not and was not disruptive. It's welcomed. We have the Haudenosaunee flag flying at City Hall, flying out on the campus. People have understood that this is Onondaga territory and have tried to work together to figure out how that can benefit everybody. And yet they, without any proof, say it's disruptive. And then those claims will upset the justifiable expectations of individuals. In other words, we can't go to court to correct these treaty violations. After the Second Circuit, we applied to the Supreme Court for certiorari. That didn't take long. And once that, next slide, please. I'll have to come back to that. So we, and the Onondagas have always said they do not belong in federal court. And that's very fundamentally true. They are a separate government with 3 treaties with the United States, the 1784 Treaty of Fort Stanwich, 1789 Fort Harmar, and then, of course, Canada. We don't belong in your courts. We belong in an international court. But we had to exhaust our domestic remedies. That's the term used in international law. And eventually we filed a case in the Organization of American States, and I think we'll come back to that. But this slide reflects Yes, might even be out of order. So in 5 years ago, we had a really kind of landmark decision handed down by Justice Gorsuch. Gorsuch is the only member of the Supreme Court who came out of the Ninth Circuit, where most of the indigenous law is litigated in federal courts. And the dispute there was over a criminal jurisdiction for a horrible crime in Oklahoma. The question is it on the reservation, and does therefore the Federal Major Crimes Act apply, or is it off the reservation and the state of Oklahoma, their law applies? And what Gorsuch wrote was that it was on a reservation because Congress had not acted to diminish the reservation. So he clarified that states have no authority to reduce reservations. The Constitution, again, Article 6, entrusts Congress with the authority. And once Congress has established a reservation, and they do that by negotiating a treaty and ratifying it, then they have established a reservation. Then only Congress can diminish it or terminate it. And regardless of who owns the title, that's why that square in the military tract is still a reservation. Next slide, please. Well, let's go back. Sorry. And so what that means here, now, what's not said by Gorsuch, he does not use the term plenary power anywhere in his opinion. And yet he repeatedly refers to it and invokes it, because after these quotes, he says, Congress certainly could do that. They have the absolute authority to do that. Congress can diminish or wipe out a treaty or a reservation at will. But he doesn't use the term plenary power because he knows, I think, that it's a bit edgy. So that's the law today. Canandaigua Treaty is still a federal treaty, and yet Onondaga has almost no land within it. And particularly that area of 1 mile around the lake is treaty land. And we can't get the county of Onondaga to even talk to us about keeping their promise to return land on that lake to the nation. Next slide, please. So after the Supreme said no, you have to exhaust your domestic remedies before you can file in any international arena. And so in April of 2014, we filed a petition in the Organization of American States, Inter-American Commission on Human Rights, charging the United States with 3 human rights violations: allowing the theft of the land, allowing the environmental destruction of the land, and having a court system that provides no remedy for treaty violations. Those are all clearly in violation of the United Nations Declaration on the Rights of Indigenous People and the subsequent American Declaration on the Rights of Indigenous People. And we filed that in Washington. And we waited because this is a very underfunded, overworked forum. And priority is given, as it should be, to cases from Central and South America that are life-threatening. But 2 years ago, May, we achieved a milestone there. And that's where the commission accepted our case for admissibility. These are terms of art within this kind of forum. Everything has a different label in these international venues. But what that means is that we had survived a motion to dismiss, and that the commission will now rule on the merits of our allegations of human rights violations. The main defense put up by the United States is, doesn't matter. This is not binding. Because the United States has never accepted the jurisdiction of an international court. There is an Inter-American Court on Human Rights, they won't accept that jurisdiction. And in fact, 20 years ago now, two citizens of the Western Shoshone Nation, the Dan sisters, brought a similar petition and won a decision against the United States. It had to do with grazing rights of the Western Shoshone, and the United States just simply ignored it. They're not subject to any international jurisdiction when it comes to indigenous people. Next slide, please.
Well, can we do a time check?
Okay, we're almost there. So this is a friend of mine, a great book, because he lays out a lot of what I've been saying here, because it is federal anti-Indian law. And so where does that leave us today? We have a federally recognized reservation within which the Onondaga Nation should have more jurisdiction, more authority, more environmental stewardship, maybe even some income. Since it's all their land, every time a deed changes hands, the county makes money. We are trying to have conversations with the county about this. As I said, though, currently we can't even get a meeting to see if they can complete their promise to return Maple Bay to the nation. What needs to happen is diplomacy, because I think when I say that the courts don't work and haven't resolved these historic problems, you can see why I say it. And diplomacy does work. Diplomacy resulted in the nation receiving title to 1,000 acres in the upper Tully Valley a year ago, September. It took us 6 years to convince the state of New York that they could not reserve the right to tell us what to do with the land. And our federal partners helped them come to that understanding. And so the return of 1,000 acres with the headwaters of Onondaga Creek is a historic accomplishment for the nation and its people, because they no longer have a source of clean fish on the currently recognized territory. The result of the mud boils, which were caused by Honeywell and its reckless solution salt mining for over a century, turns the creek into a muddy mess. We have pictures of Chief Irving Powell Sr. taking a trout out of that stream in the 50s, that's 23.5 inches long. No more trout, at least by the time it gets north to the nation. The 1,000 acres contains dozens of the tributaries that form the creek. And in those tributaries is a struggling but surviving brook trout population. And we are working with scientists from the Forestry School, from Fish and Wildlife, from Trouts Unlimited, and a number of others to have, and we are into the 3rd year of a brook trout restoration program. It's jeopardized by a gravel mine down there, and we don't have time for that. It's important to, and we had to tour those 1,000 acres multiple times because of problems that Honeywell kept throwing up in terms of boundaries and, oh, we won't agree to clean that up. And when we went out there with the Onondaga people, particularly the women and the children, and to see them interact with these 6 waterfalls, streams, walking along and saying, oh, that's a plant I haven't seen since my aunt showed it. The interaction with the land is just so invigorating and so rewarding to view. So that's where we are today. We have a federally recognized reservation that people ignore. When I raised that fact in the Columbus Monument litigation, the nation filed a friend of the court brief in support of the city. The local judge here says, I don't know what that means, Joe, and threw our amicus out. The appellate court granted us that status, but we need to understand this history, as ugly as it is, because it's forced removal, land theft. We haven't even talked about the boarding school, the Thomas Indian School over in Seneca territory. we need to find a way to heal, to work together, to recognize this history, to recognize the rights of the Onondaga Nation, to grow their territory, and for the four governments, the state, federal, county, and nation, to come together and work for justice, work for peace. That's what I'm supposed to be doing. So thank you for listening.
Question, room for one question. And Brian will.
And because I'm not on the mic and our friends who were not here, I'll just ask you to repeat it. I'm Brian Hoke. I'm a former board member. Thank you for being here. I enjoyed, as I'm sure everybody did, your remarks. A question, how best for people in the community to support these efforts, in particular, whoever sits in the mayor's chair come November of this year, what can folks do to support the efforts that you've talked about?
Well, the issue of Maple Bay.
You would use the mic if you would, just because we have people on Zoom. Thank you.
The issue of Maple Bay is really the current problem. No other way to put it. So in 2011, the county legislature passed a resolution because of the efforts of Lloyd Withers, who was a retired businessman, and said, we're going to return land on Onondaga Lake to the nation. At that time, it looked as though Murphy's Island looks great. It's got great cottonwoods. It looks like a good place. Well, it turns out to be the most polluted on the lake because of all that Honeywell and everybody else dumped there. And then we spent years touring the lake to find an acceptable, a usable spot that wasn't overly polluted. That is Maple Bay. Maple Bay is down on the river end of the lake. You have Willow Bay over here, and the other side of the river is Maple Bay. 2016, then county executive tried to get the legislature to rescind that commitment. They balked, pushed back, and reaffirmed the commitment to return. I don't know if it identified Maple Bay or just some land on the lake. Shortly after he took office, our current county executive walked Maple Bay with Taradaho and others and promised to keep that commitment. I have the political capital to do it. Since then, he's thrown up excuse after excuse after excuse and will not even meet with us to complete that promise. And so we need people to think about whether or not county government is really operating well, whether or not we have any checks and balances over there, and to help us hold the county to its promise and return land on Maple Bay to the nation. It should be a World Heritage Site. The formation of this confederacy there has been recognized by Congress, and yet we get fish tanks and can't get property for the Onondaga people to use. So we need people's support there. Let's get a balance in the legislature that could hold a hearing as to why their commitments are being ignored. That's one way people could weigh in.